Good afternoon. My name is Shana Beggan, and I'm partners with Mike Pellow and Steve Alonzi. I've been an attorney since 2000 and practiced primarily clerking for the Supreme Court and then as a prosecutor in Denver, and then shifted to criminal defense and civil litigation, which we've been doing for the last 15 years.
So my name is Mike Pellow. Hello, everybody. Thanks for watching the CLE, and thank you for supporting the Boulder Bar Association. I've been an attorney for about 36 years now, 20 years with the Denver DA's office. That's where Shana and I met. We started our law practice in 2008. So in April, we just celebrated 15 years as a law firm. Congratulations, Shana.
Congratulations, Mike.
Thank you. We are a three-person firm that does about 85 to 90% criminal law. Our office is in Denver. We do lots of practice in the metro area. We did ADC, Alternate Defense Counsel, for 12 years out of Denver. We've just recently switched to Boulder, and we now do ADC out of Boulder. We're kind of an interesting firm. Our major cases get basically three sets of eyes. We have a team approach on that. Some firms do, you bring it in, you kill it, you eat it. That's not how we work. We kind of have a team approach, unless it's things like first-time DUIs that, frankly, some of us could do in our sleep. Although every case is different and every individual is unique, so we don't try it in our sleep. But we have no support staff. So we do all of our own motions, all of our own pleadings, all of our own emails, all of our own answering telephone calls. And one of the things we're going to talk about today, one of the major things, one of the big words for how to earn the respect of everybody and zealously advocate your client, is communication. Communication is extremely important. And I bring that up right now because we have no support staff. If we can communicate with our clients, I feel everybody can. So that's who we are, and that's our firm. And Shana, back to you.
So it's a long title, and one thing you'll notice is we are not tech savvy, hence why we're kind of dark. We figured the content was more important, plus the sun's right behind us. So this is a long title for a CLE, but we wanted to blend kind of the ethics of being a criminal defense attorney along with trying to earn the respect. One of the things you're taught all the time is win the courtroom. You make that your courtroom. And I think you do that through respect. And you first have to have the respect of your client and the court and opposing counsel. And while that might sound something people are free to disagree, of course, but I think if you listen, you'll understand why we think this. So we'll start with when we talk about your client. So with your client, I mean, Mike was just talking about communication, and this is generally going to be geared towards your first time client. Many of us, you have repeat clients. They come back. They probably come back because they already trust and respect you. So certainly this applies to all clients, but we're really talking about this brand new client, whether they're court appointed, whether they're pro bono, whether they're a private hire. When you meet them, I think it is extremely critical that you establish expectations and boundaries right out of the gates. What that means is really talking about those awkward things like, look, we're a three-person firm. We don't have staff. If it is urgent, our clients all get our email and they get our cell phones. But we also very clearly tell them we have families and we are not 24/7 on the clock. We can only be good for them if we're also taking care of ourselves. So while they're free to text us or email us, only if it is genuinely an emergency, should they text us 911 and then call. When we establish that out of the chutes, we also tell them, but we will get back to you within 24 hours, even if we're in trial. Sometimes it's our third partner getting back to somebody. Sometimes it's us in the evenings. But I think 24-hour rule and those very clear boundaries are important. The other one rule we have with our clients is we're never going to lie to them. And we tell them it's always beneficial if they don't lie to us because they're the one the case is about. But we understand they don't know us, and we're going to earn their respect, and we're going to give them our respect, and we will never lie to them. We're not going to promise them certain, oh, if you sign us, we guarantee this case will get dismissed. That's never going to happen in our case. So we want to establish those right out of the chutes.
So another important thing about the first-time client, first meeting a client, and I would say this applies to everything we do. interacting with opposing counsel, interacting with the court, is a presumption of decency. Presume the best of other people until they show you something else. That's what we try to go forward on that premise all the time. Your first time client presents, and I had somebody really recently send some really kind of abhorrent text to an ex of his. Try to keep a poker face. This person is sharing extremely sensitive information. It turned out he's OCD. He's seeking treatment for that. And it turned into an hour initial meeting. That can happen. You have to be open-minded to somebody sharing all kinds of secrets from their past with you, unexpected by you. And it's kind of hard to say, okay, that's your 5 minutes, go away now. Presume the best, presume people might have made a mistake. They might actually be innocent. Lots of people are. Lots of people get stuck in the system for no good reason. And because the explanation doesn't make a lot of sense at first, that doesn't mean somebody's lying. It doesn't mean they're prevaricating. It doesn't mean anything of the sort, or they're shading. It could be they're not comfortable sharing things. And so a presumption of decency, will probably bring up those words again when we talk about opposing counsel and the court, but that's a starting place with the client as well, a first-time client.
And one of the things Mike was just talking about is when this is an issue that different attorneys do it different ways. And we are not here to say that this style is the way to go for everybody. But our approach is when we first meet the client, we actually want to introduce them to ourselves. We want to get to know them, but we do not talk to them about the facts about what happened. Obviously, there's exceptions, but the vast majority of the time, what we tell them is the reason we don't want to go into what the facts are is we want them to understand this is the government's job. The government is pointing the finger at them, and it is their responsibility to be able to prove it. But we also, and this will get into some of the ethical rules that we have on the next slide, but we also want them to understand sometimes when you meet somebody, you want to put your best foot forward, and sometimes people aren't ready to put their best foot forward or want to shade it in ways. And we don't want to get in a position where they've said one thing and now we need to change that situation. So we often tell them that the first meeting is about getting to know them, getting to know us. We talk about generalities around the charges. We may talk very generally if we have an affidavit, but what we want them to understand and be comfortable with is that we are competent and we are capable and we are ready to dig in on their behalf. The case is not about us. And one of the things I have noticed in over in order a quarter century to being an attorney is people try to attorneys make it personal. It's their case. It's my win. It's my loss. It's not about us. It's about the client, and it is very personal to the client. So when they act inappropriately, when they are overwhelmed, when they're panicking, we have to remember it is not about us. So reviewing discovery, we think, is extremely important. When our clients are in custody, we do not leave copies of their discovery with them, but we explain why. We take all the time they need. We come out, we'll come back out with it, but we explain to them, look, nobody likes very few people like to be in jail. Very few people want to be in jail. And a lot of people are looking for any way to get a step up in their case or to sweeten their deal. And if they can get their hands on the discovery, they can say, we were sitting out there and he was just really having a hard day and he told me he did XYZ. Or she was in here and she was crying and we were talking and she told me ABC. And it almost always conforms to the discovery and what the government believes happened in the case. So that is something that is a very hard and fast rule for us. We do not leave discovery with our clients. They have our card. We'll come back out. We talk about it as often as they need. We go to the jail and visit them, but we will not leave it with them. But we do want to make sure they understand. And it's super important to us. We use a lot of words that as attorneys, they make sense to all of us. And some of our clients are very sophisticated and some are really not sophisticated at all. And it's really important you're paying attention, you're watching them. I often like to say, okay, if I'm talking about a plea offer, I want them to tell it back to me in their words. What do you understand this offer means? What's your understanding of what your requirements are? What are probation's requirements? What are the government's requirements, especially in cases like a deferred judgment? It's really important that they understand it, because many times it's kind of really loud and like background noise, and they're hearing it and they're nodding, and you think that they're understanding it, and they walk away and they don't remember what they just agreed to or said they understood.
One of the most important things in dealing with a client and having a good relationship with a client is incorporating that client's support systems. Hopefully they have some. You will probably encounter, if you practice criminal defense long enough, the client that has absolutely no support systems. And those clients are difficult because you will spend sometimes your own time, if you're a good caring attorney, to try to help that person establish some support system. So one of the most important support systems for many clients is their family. Some families want to be involved. Some families definitely, desperately do not want to be involved. The family that wants to be involved is of primary concern for our talk today. They may pay for the client's representation. We put right out in our fee agreement, and we talk about this at our first meeting. It doesn't matter if somebody else puts up the money. It doesn't matter if your parent puts up the money. They're not the client. They can't call and talk about your case with me. You have attorney-client privilege that is personal and unique and individual to you, Mr. Client, and your family does not have it the same way you do. We also will put in a fee agreement. I think this is wise in writing. You are authorizing us to speak to, and then certain people, the prosecutor during the course of plea negotiations, any expert witnesses, if there are any. DMV, if you have to have a DMV hearing. So we get them to initial and sign that we are going to specifically talk to certain people. And then if they specifically want, we talk to my mom, we talk to my dad. We establish those things, those kind of guidelines, boundaries up front, so that they know the 24-hour rule that we tried to follow, strictly adhere to, applies to the client. It doesn't necessarily apply to calling your great uncle back within 24 hours. Maybe we will if you're out of touch and out of pocket and you authorized us to do that, then we could do that. So that's another consideration, is dealing with family members. And again, you want to deal with them in an appropriate, professional, polite manner, because this is your client support system and it's important to the client.
And part of talking with families, another thing to bear in mind is sometimes we can be the bridge for our clients. Sometimes family members are going to be witnesses if it's going to trial. Sometimes they're already witnesses in the case. Sometimes that relationship changes, the dynamics change. And so the more we understand that, the better we can help our client. We have had situations where family is beyond supportive, but maybe their well-intentions are not actually helping our client long-term. We have had situations where it's a split family and client is very, very comfortable with us talking with one parent and not with the other parent. If it's a juvenile case, those nuances become more tricky. You have a GAL and you want to explain to everybody the parameters, but generally speaking, you still need to involve the parents to some degree. When we get to plea discussions, it's always best, because as the attorney, you're in your client's lives for kind of this blip period of time, ideally. And then you're going to hand them off ideally, and their support systems, you want to be able to step in and help them through. But you also have to be kind of watching and reading. We've had situations where the client, for example, really wants to take a deal. We just had a homicide case where the client really wanted to take the deal we had. It was a very good deal, all things considered. But there were strong self-defense overtones in the case. And so, of course, the family, who loves him dearly, doesn't want him to take a plea. And they really couldn't understand. And so it requires the client trusting you enough to talk with the family. Then it requires the family trusting you to listen. So we actually had to set it over. And by the time we actually got to doing the plea, everybody was in agreement. the family, everybody understood why this was in their son in this situation, their son's best interest, and why their son wanted to take this plea. If you don't develop that rapport, if you don't develop that trust, that's when you can start to get into situations where people start to file grievances or make complaints, or in today's day and age, almost not as professionally harmful as a grievance or a complaint, but with everybody being so tech available, people can come online and make bad comments about you, and then you have to overcome that. And so if you treat people with that presumption of decency, if you take the time with them, and if you make sure they're understanding, and you make sure that there are boundaries and they understand why there are boundaries, we've been very fortunate in our practice of having a great deal of respect from our clients. Another thing I think that helps us is that we don't make promises that we can't keep. I said before, we don't say you're going to dismiss, but you don't want to be in a situation. If you tell your client you're going to go talk to the prosecutor about X, you need to do it. If you tell your client you're going to seek a certain resolution, you need to do it. You need to follow through. If you tell your client you're going to have an investigator do certain things, you need to follow through with that. And if for some reason that can't happen, just explain it to them. So I think that all kind of helps set the tone of expectations, communication, professionalism. So then as we get ready for any court date, any hearing, any next steps, another big thing for us is we're always prepared. And our clients, yes, I know the courts now let them know when their next court date is, but with the rarest of exception that I can't think of right now, we've met with our clients or talked with our clients before every court date. We remind them of the court date. We explain what's going to happen at that court date. And we are very clear with them so that there's no surprises. Court is extremely stressful. It doesn't matter if it's first-time DUI or if it's a homicide case. It's extremely stressful. So oftentimes the only place our clients might be able to see their family is in the courtroom. They don't know what to expect. They are nervous. And so if we prepare them for what's going to happen, they are calmer. And I think it's our job to do that. If there is that exception and something unique is going to happen, or something we didn't prepare them is going to happen, ask to pass the case. Ask to pass the case and go talk to your client. Sit with them and calm them down. You don't want that to unfold at the podium on the record with the court. You want to take the time to calm them down and explain whatever the situation is. And that's why we like to say, be the lifeguard.
And that's the final principle. And it's actually the first and the final principle, and a principle that really guides us. When Shana and I were looking at leaving the DA's office and starting our own firm back a little over 15 years ago, we met with a gentleman that some of you may know. Used to be everybody in the defense practice knew Craig Truman, wonderful defense attorney, full of great knowledge, full of ethical knowledge. We reached out to him a fair amount. And one of the first times we reached out to Craig was when we were getting started, and we met with him to talk about being a defense attorney. We'd both been defense attorneys for a long time. Lots of prosecutors think, hey, how hard could this be? I know the criminal law. I'll just switch over to the defense side. Well, that's a rude awakening for most prosecutors. You get babied when you're a DA. Everything gets done for you. You got an investigator, you got a victim advocate, you got everything. And you go from that half a block walk from your office to court to you're driving all around the metro area. You got no support staff. You're doing everything yourself. It's a huge change. And one of the things, luckily, Craig Truman told us that prepared us mentally is, you're like a lifeguard. Your client is a drowning person. They don't mean you ill will as a drowning person, but they're flailing around out there. They're in deep water. They're panicking. And if they get a chance, they'll grab you and take you down with them. And Craig says, that is something you really wish to avoid, which is true. Most of your clients certainly mean you no ill will, but if they're panicking and grabbing, the most important thing is get rid of the panic. Attorneys can't panic. It's rule number one. We can't. We have to be the lifeguard. We have to save that person. And it's important to remember that for professionalism. Clients get under your skin. They can be irritating. We like to give out our cell phone numbers because clients have emergencies. They're late for court. They're half an hour late. They got a flat tire. You're wondering what to tell the judge. You'd like to have a text that says, hey, I'm sorry, I'm half an hour out. I got a flat tire. Some of your clients will abuse that privilege. They'll call you at 2 a.m. for no particular reason, just because I'm feeling like chatting with my lawyer. Well, get past that, because it is a big deal for clients. If they have your text, I would do it with discretion. But if you have that, you have a strong bond with that client that almost none of our clients take advantage of. And you can really serve as a lifeguard in that situation.
And so tying all those together, there are some ethical rules that, when you're talking about the client, these are the ethical rules that I think come into play. And I started by saying we're not super tech savvy. On our screen, we have hyperlinks to these rules, but I don't think it works on the share screen. So generally speaking, when you're first signing a client, make sure you do your conflicts check. We had a recent scenario where we were appointed on a case and we did our conflicts check and we had no conflicts known based on who was appointed, based on the client's name and based on the arresting agency and based on the list of witnesses. However, there was a probation case that we didn't know until we actually got the discovery. And in the probation case, that was kind of tied to this new case, there was a very, very, very big conflict. So we were able to immediately inform our client and immediately inform the court, but you have to make sure you're doing that. And if you have a case where you're concerned there might be a potential conflict, you can do, if it's appropriate, get the waiver. It's just smarter to be honest and open about it. I know I've talked to some private counsel. There's times when business is great and there's times when business is slow and you're like, it's not going to come up. They don't need to know about it and just want to skirt it because they need to sign a client. I promise you, those are the times it's going to bite you in the butt. Maybe not in the near, but in the future. Because if you don't have your client's trust, and if your client learns later there was something like that, that's when it's an issue. So just take the extra time to do the conflicts check and go through the waiver. One of the things, though, that I think we have, there's a conflict between confidentiality and zealous representation. So one of the things I think that happens the most in criminal court is, what do you share with your client in terms of, one instance would be the DA's called you and told you, hey, your client's got a warrant. And you have a court date in 3 days. Do you call your client and tell them, hey, you got a warrant? And then they show up for court? Do you wait until court? Do you try to get them in to process it first? I would say you do more digging. What's the warrant for? Is the warrant because they're in violation of pretrial? Is the warrant because they're in violation of probation? Is it a new case? Do the digging, especially in today's day and age where some of the jails won't even process people and take them into custody. But I do think you owe an obligation to talk to your client and talk about it, the way things look better and the way things look worse. If you tell your client they have a warrant, then they don't show up for court, that can look really bad. But don't tell the DA you're going to tell your client and then not tell then you got to make sure you're always being honest with everybody to the extent you can. I think another one we deal with a lot.
Well, here's another situation. You get a call from a family member, speaking of dealing with family members, and the family member says, hey, Tommy, your client, just left the house. He's going over to the witness's house. He had a knife in his hand and he's making a bunch of crazy threats. What's your obligation then? You have attorney-client privilege, obviously, not with the family member, but you do with your client. However, there are ethical obligations, like if your client is about to present serious harm to another individual, you have an obligation to warn somebody, or you may, if you have a reasonable belief that your client is an imminent threat to themselves or somebody else, you have an obligation to report that and to do something, to not just let it happen. So that's something where you want family trust. Obviously, you want to know this is a family member, dad, uncle, mom, whoever it is. Hopefully you've talked to him before. Hopefully it's somebody you trust that's calling you up and going, oh my God, and they're going to be panicking. And then you got to get yourself through that. Another example where ethical rules conflict is we all have an obligation of candor to the tribunal, be honest with the court. And we'll get to that on the court thing. But in terms of with the court and your client, you also have an attorney-client privilege with your client, and you have the duty of zealous advocacy and representation of your client. Let's say, here's an example comes up all the time. The DA provides you with discovery which says your client has no drinking and driving offenses on their record. Your client says, well, you know, back in Connecticut about 10 years ago, I got pulled over for drinking and driving when I was 19, and I'm not really sure what happened with that case. I might have got convicted. Well, the DA is going to make you an offer contingent upon the fact that your client has no prior drinking and driving offenses. The court may inquire of you or your counsel or both. My understanding, Mr. Client, is this is your first time drinking and driving offense in a lifetime. Is that correct? Mr. Pellow, is that your understanding of your client's record? Frankly, I don't understand the reasons why a DA or the court would put defense attorneys on the spot like that. It's their burden to establish my client's record, not mine. But you get asked a pointed question in court, you have an obligation of candor. You cannot lie to the court. You cannot lie to the court. Don't try to shade that one. That's one, just stick to that. Do not, you cannot. And so, Your Honor, there are various ways to approach it. The discovery I've been provided by the DA indicates my client has no convictions. If you have discussed it with your client and your client is okay with you bringing up the fact to the DA that they got pulled over in Connecticut 10 years ago, you may want to present that to the client because you don't want to blindside the DA and have him or her coming back pissed at you later, or more likely pissed at your client. And so you want to be upfront, you want to be ethical, you want to share this. If your client authorized it, you can say to the DA, look, my client believes she got pulled over 10 years ago in Connecticut. She doesn't know what happened. I don't see it in your records. I actually had this happen with the client. He was in the Army in North Carolina, and the DA and I both dug around. Neither one of us could find any information, but I was upfront with her, and she made a record at sentencing. Judge, Mr. Pellow has revealed this to me. I dug, I looked. We know he got disciplined by the military. We just can't find a conviction, so I don't believe there is one. And that's the best way, that's the best step you can be on if you can get to that. But it takes some work to get to that point because you've got to juggle all of your ethical requirements.
And that's kind of, again, the due diligence and the communication. We do a lot of that digging ourselves. We know what the DAs are going to do. We know what probation is going to do. So we don't want our clients sitting there in probation's office and the probation officer grilling them about this prior that we didn't disclose to anybody that the client talked to us about. So it is a very routine thing for a client to be sitting in our office and telling us about something that then I just start making phone calls. You start calling the court of the jurisdiction they thought it was in and just seeing, do you have anything on there? And you do your little bit of investigation. You can usually track down what it is, and you can usually figure it out. And I will say more often than not, there's a nuance there, but I've had it work to our clients' benefit. When there is a conviction that probation would have found out about, but the DA didn't know about, and we sit with the client and we talk about, okay, we can not say anything, but you're going to be asked this on your plea agreement. And then you're going to be asked this by the court at the time of the plea, and then you're going to go to probation. And it's not going to take much of a search for them to find this. So we can certainly remain quiet and say, based on the discovery we've been provided, this is the only conviction my client has. But make no mistake, what's going to happen is you're going to get to probation, it's going to get kicked back here, and now the court's going to know that you represented something that was not true to the court. So as painful as it is, because it's kind of nice to think, oh, I'm about to get away with it, it's oftentimes better just to own it up front. But it's really hard. And finally, we come back to where we started, which is communication. The number one thing attorneys get grief for, criminal defense attorneys get grief for by attorney regulation, is lack of communication with their clients. It's the number one thing. It's been the number one thing for years. And it's people get overwhelmed. They have the annoying client that they don't really want to talk to. They've talked about it 10 times already. We've all been there. We are empathetic with that, but just have that communication. If there are no surprises, and as long as the client feels like they were heard when they come in, treat them the same way in the same amount of respect as when they go out. Make sure as you close those cases, they understand what their expectations are. Make sure they understand you no longer represent them. If they're on probation, if they get into trouble, that you're happy to, but that's a different fee agreement, and make sure you've walked through what they need to be doing. If you're communicating with your clients, I think the chance of you being grieved are extremely low. Anything?
I agree, as long as you're professionally practicing, absolutely. So onwards.
So now we'll talk about how to protect your reputation also with the court and zealously advocate with the client. We've kind of touched on some of this, but the court, it's super important that you protect your reputation. You're only as good to your clients if you're only good to your clients if you have a good reputation in the court. If you come into the courtroom and you already have baggage that you're unfairly saddling your client with, it's putting them already behind an 8 ball. And it's a place nobody wants to be, and you don't have to be. So in preparing for this, we talked to several of the judges on the Boulder bench, both the county bench and the district court bench, and overwhelmingly what they were talking about has been summarized by Judge Butler, who he describes it as the 4 P's and the 3 no-nos. So I'll take the 4 P's. The 4 P's, there's a lot of overlap. He said, be polite, prepared, punctual, and professional. So punctual, we've all been there. Everybody gets set at 8:15 and there's 40 cases on the docket. Why do I need to be there at 8:15? I know my client's out of custody. Doesn't need an interpreter. They're not going to call him first. And so it's a waste of my time to do that. Just be courteous. Let the court know when they set it. Okay, judge, I'm double set that morning. I know my client will be out of custody, so I'm going to be here a little later. That little bit of courtesy, just showing it to the court and talking to the court and letting them know ahead of time, and also telling your client that ahead of time, you'd be astounded at how much that carries with the court. Because the court it's looking at everybody in the gallery. It looks at how you're interacting, and it knows who's there and who's not, who's on time and who's not, and will respond similarly. Same with being polite. It's sometimes really hard. I was in the Boulder court a couple weeks ago, and I was watching a defense attorney trying to have a conversation with the DA. And my blood was boiling because he was doing nothing wrong. He was trying to have a very relevant, very important conversation. And he was basically getting the Heisman. And this DA was not either, she wasn't hearing him, or she wasn't listening.
Or she didn't care.
And it was, my blood was boiling on his behalf. It was so wrong. And she eventually walked off, and he turned to me and goes, was I doing anything wrong? He goes, sometimes I can get rude. I said, no, you were being extremely polite. But it was also obvious he was extremely frustrated. So when we were all in the courtroom, he was professional, but he let the court know it was clear his frustrations, and he let the court know in an appropriate way. So the court is watching all of that. The court is watching how the interactions are going. So when you're expected to be polite and professional, it doesn't mean you can't be really frustrated. It doesn't mean sometimes those gloves don't come off. Just like the prosecutors are allowed to strike hard blows, they can't strike foul blows. The same rule applies for the defense. You have an obligation to zealously represent your client. And if it's time to strike a hard blow, do it. But don't strike a foul blow. Don't make it personal. Don't make it you versus that attorney. It is the government versus your client as represented by this attorney, and make sure it's the right setting. Does the court need to be involved in this? Does a chief need to be involved in this? Is it just a bad day and you let it go? And we all have those. And be prepared. There is nothing more frustrating for the court than when parties show up and they don't know what's happening. The court just wants to know what's happening that day. If you do those, the court will see it, and I promise you it will play into the reputation. And the judges all talk, not just within Boulder, they talk throughout the state. So you are only serving your client's best interest by earning the respect of the court.
So the three no-nos, but before we leave the four Ps, I want to touch on one other thing. When I was a DA for many, many years and getting ready to try a case, one of the things I would say to myself, probably to pump myself up as well, once again, on this trial, I've got home court advantage. Because DAs always do. They appear in there all the time. They know the clerks. They probably know the sheriff deputies. That could be a good thing for a DA, but if they have a personality that's no bueno, that could be a bad thing for the DA as well. And there is no reason why defense attorneys who are getting ready to try a case can't have home court advantage either. And what I'm talking about is if you go into the courtroom, you've never been in there before, go up to the court clerk and say, "Hi, I'm Mike Pellow. I'm appearing on this case." Usually they'll tell you their name. If not, what's your name? And file it away. Remember it. Talk to the sheriff deputy. "Hello, sir. I'm Mike Pellow." Put out your hand. People will want to shake your hand if you hold it out to them. And then you've established a bond, whether they want to or not, really. And they will then associate you as a professional, prepared, polite professional doing your thing, doing your job. It's amazing how many defense attorneys think, well, DAs or cops think I'm on the dark side because that's what they say. Well, they're people, and people want to talk to people, and people want to know what other people are doing, and people like friendly people. And defense attorneys can be all of those things. You can be friendly to the clerk, a judge. Walk up to the bench, ask the DA, "Will you come up to the bench with me? I want to introduce myself to the judge." It's amazing how many attorneys don't do that. But judges are people. Judges are like, "I wonder who this new person is in my courtroom. Oh, I've heard about him or her, or maybe they haven't." Well, go say hello. Nothing wrong with that. That's a good thing. Establish that courtroom as your home court advantage. Now the no-nos. I said this with regard to the court. We have both said this with regard to communicating with your counsel. Don't lie. Life's too short. Don't drag baggage around behind you. It's bad enough our clients do it to us. Don't perpetuate it. Honest communication is an amazing thing. Even like saying, "I don't feel so good today," to a clerk. I'm just having some issues. I don't know. It's amazing. Do not sleep with your client. That, of course, is a euphemism. You might be okay if all you did is sleep, but that really means don't have sexual interactions with your client. And that rule has changed some. Attorneys who say you're married, an attorney could choose to represent his wife. I would not. I would feel like my wife had a really good lawyer, but you're not objective. A doctor shouldn't be operating on himself or his own wife, I don't think. Professionalism requires objectivity, so that's not a good idea. And then, the obvious, don't mix your money with your clients. Communication is the number one way to get grieved. The number two way to get grieved is that. We know all the things of what you got to do. You got to have a cold tap. You got to have a trust fund. You got to bill appropriately and correctly. And it takes a lot of time and it's a pain in our behinds, but you got to do it to mind the three no-nos. And those are all very important things.
And again, just to touch on the ethical part of the presentation, the ethical rule that is at issue with the court is candor to the tribunal. We already talked about this a little bit, but you've got to balance zealous advocacy with your obligations to the court, and you have to nuance it with attorney-client privilege. So we talked about the situation Mike had mentioned where, what if you get that phone call from the family member? We actually were in this situation, and we had a loved one calling us that our client had taken off with a weapon and was headed to the witness's home. And we had not been defense attorneys that long, so we called two very, very trusted longtime defense attorneys. One is now our partner, and another one, and got their feelings. And then we had to call the police. Fortunately, as we were calling the police, we were actually getting a call from the police that our client had been at a Starbucks and that he was very agitated. And then we were in a different sticky wicket because he was in contact with the police but didn't have the weapon anymore. So now we had to deal with that issue of figuring out where this weapon was if it was in a public place. So you've got to walk those lines very carefully. We had another situation where a client brought in a phone. It was a domestic situation, and there was a lot of evidence protecting our client that was on the phone that they wanted us to have for purposes of defense. But there was also evidence on the phone that played into the fact that they had committed a portion of the crime they were being alleged to have committed. And that's a really sticky wicket. And what do you have to do? And where do you go with that? And what is privileged? And what requirements do you have with the court? Probably the hardest one is, when your client lies, we all know what you do if your client's going to get on the stand and lie. That's not the one that I think occurs as often. I think the one that occurs more often is your client lied to you and got you to unintentionally misrepresent something to the court. And it is a really difficult position to be in once you realize that. Mike had that very situation and had to deal with the client and with the judge, and was able to do it in a way that actually still protected the client, but protected us as well. So always minding all the balances of those, but the fundamental one is you're an officer of the court, and you have to make sure your clients understand that. Again, when we meet with clients, we tell them we are very aggressive, we are very good at what we do, but if you're looking for somebody that will just avoid all the rules and go for the jugular no matter what, we're not the right fit for you.
I agree. Totally.
So then it's opposing counsel. And, opposing counsel, sometimes it's hard to stay calm. You have to be professional. I don't know. I'm hoping some people watching this remember who Bobby Knight was. And my dad always loved him as a coach. But my dad also had a lot of road rage in him. I don't think the courtroom is the time to unleash, or with opposing counsel, the time to unleash your inner Bobby Knight. You don't lose your temper. You don't come unglued. You don't get all slippery and slimy. You are going to interact with these attorneys again and again and again. Some of them may go on and become judges. Some of them may go on and become defense attorneys. Some of them may stay in the DA's office for a very long time. Some may be the elected DA. You're going to cross paths. If you have a thriving practice, you're going to cross paths over and over and over again. And how you treat them matters. And sometimes it's really, really hard. We had an instance where opposing counsel on a restraining order case I don't use this word often. Mike knows I do not say this often. I don't call people a liar. She lied in pleadings. She lied in attachments. She lied to the court. That was obviously extremely difficult to deal with. And we dealt with it with the court because you have to be able to stay professional. And even though I was enraged, and even though she was not being honest, and even though we were going to have a very awkward conversation with the court, I still stayed professional with her. I still treated her the way I would want to be treated. As Michelle Obama says, when they go low, we go high. But as my mom said, is 2 wrongs don't make it right. And that has always stuck with me, that if I responded in kind, even though you're tempted to, and even though it might feel good in the short term, it's not going to play out for you or for your client in the long term. I think our reputation and what you do with it is something you cannot afford to lose. And the one thing that my grandmother always taught me, but I think it's extremely important every day, is the one thing you're in charge of and you're in control of, no matter how ugly it gets, no matter how awful it is your attitude. And that attitude and that how you approach something, it sets the tone for what's going to happen. And I think when you act that way in your professional when the time comes that you have to hit those hard punches, you're going to be given some latitude by the court because they know this is not something you do all the time. You very rarely do this, so everybody's listening.
And along those lines, there's a lot, almost a barrage of information defense attorneys get, whether you're a public defender, whether you're alternate defense counsel. I think it's consistent with the current mood of the country, frankly, of the temptation to divide each other into warring camps and label each other and say, you do this, you do that, this makes you not good. People are taught, fight the man. You know, the man is the government. The man is bad. The man wishes to do evil things, nefarious things to your client. And you've got to fight him at every opportunity, whether the man is actually a woman DA or a man. That's self-defeating to me. And yeah, I was a DA for a long time. And part of that is I don't like it when people approach me and are belligerent to me and make the assumption that I'm racist, that I'm hide evidence, anything else about me just because I happen to be an attorney who works for the government. And if that's your approach, I would highly recommend you reconsider that approach. Most of the time, there's no reason to be fighting with anyone. As Shana says, there comes a time when it's showtime, it's fight time. It's time to throw those hard blows, but never low ones, never foul ones to anybody, not to a DA. Like Shana says, you're going to see that person again. And the one thing you can also control, other than your attitude, is your own civility and your own professionalism. And you can take a professional approach, even when someone ignores you. Even if I had a DA, I hadn't been a defense attorney very long, and she hadn't been a DA very long. And I was appearing on a case that Shana had happened and handled initially. And I said, well, my understanding, and I showed the back of my file, I had said, my understanding is that this was the offer conveyed. And the DA says, well, that's just what your associate wrote down. That's not the offer. Well, I was appalled. I was like, is this the way other DAs throughout the state practice? And then I went and talked to Shana, and she's like, you know what? She could have been having a bad day. Could have been sick. You don't know. Maybe she's having a bad issue with a boyfriend. You don't know. You just don't know. Why don't you try to give this person a call, say, hey, we didn't get off on really the right foot, but I really want to discuss that off. Well, it turns out later, this person was only a DA for about a year or so. She went to the defense side. We really like her a lot. She's a really nice, kind, professional attorney. She was having a crappy day. It happens. It happens. She and I didn't know each other, but if you let that be a grudge, if you let that start building the concrete between you, that I'm going to fight that person, it's self-defeating because you're going to have to go back to that well again and again for other clients. And you want to do your best for your client. And I am not saying you have to stand there and act like you like it. That's not what I don't do that. I would say I don't really consider that professional conduct. Yes, my law partner wrote this down because she talked to an associate of yours, and this is the offer. And I really don't appreciate what seems to be an implication that one or the other of us is lying to you because that's not what we do.
And in the end, she came around.
Absolutely.
She apologized and we moved forward and we have a fond respect for each other now. I think one of the most shocking things Mike and I discovered as we became defense attorneys was, I think almost right up there in the top requirements and obligations in the job, besides communicating, is educating. It is astounding how much prosecutors don't know, families don't know, clients don't know, even the courts don't know. As a prosecutor, I specialized in, for example, and one of the areas I specialized in were sex crimes, family violence crimes. And, I had absolutely zero idea how invasive and overwhelming and abhorrent SOISP was. It is something that hurts to know that I'm not mad that I made those offers. I'm mad that I never took the time to really understand it. As I shifted to the defense and I saw it, I realized I could do something with this, and that was to educate people that were in that role, to have those conversations, to explain, my client, for example, on a DUI, if your client maybe is a pilot, and the ramifications with the FAA and the ramifications, a young DA doesn't know that that's going to impact their ability to be a pilot at all. So if you slow down and do the legwork and educate them, you'd be surprised. As long as you do it in a not condescending way, in a sharing of information way, if you educate them about other issues that are going to arise from the case that they wouldn't have a way of knowing about, if there are the overwhelming overlap between family law cases and criminal cases, they're not going to know, the prosecutor is not going to know what's going on in the family law case. So if it's appropriate and if you have the information and it's the right time to do it, share it. Share it. Some prosecutors abuse their power, and we should all abhor anybody abusing their power. But the vast majority don't. The vast majority think that they're doing the right thing, and they want to do the right thing. And if you understand that and you're willing to talk to them and you can slow it down, oftentimes that can open the door to have better and further discussions. I know when I was a prosecutor, my biggest fear
As it should be.
was convicting an innocent person. I was terrified of it. Now, right along that sticky note that sat on my computer every single day that said, do not convict an innocent person, was another sticky note that said, and don't let your mistakes be the reason a really violent person goes back into society. I think that I'm not unusual. I don't think I'm a unicorn in that regard. I think the vast majority of DAs get pumped up with being told they wear the white hats and they're doing justice and
They represent the victim.
That irritates me. They represent the people. The victim, those labels don't help any of us, but they want to do the right thing. And it's important that we slow them down and help them see the errors of some of those, or the fallacies of some of those thoughts. At the end of the day, what we can't do is make it personal, and not so much because it doesn't serve your client, but because it's going to eat you up. And so as we talked about fairness to the ethical rule here, fairness to opposing counsel, just really quickly, is just don't lie. It's again summarizing, don't lie, don't hide evidence. Make sure you read that rule if you're in that sticky scenario, so you know how you have to handle it. Don't misrepresent the law. But as we wrap up, this career is awesome, and there's no one right way to do it, but it's also super stressful, and it can tear you apart. It can really, really, really drive you into the ground, and we need to be looking out for each other. I'm not sure why, probably because of my technological issues, but across from the no one right way, now it's in there twice, but it said, take care of each other and take care of yourselves. If you're not taking care of yourself, you can't help your clients. If you see your partner, if you see your friend, if you see colleagues, if you see opposing counsel and they just don't seem to be acting the way, stop, take a moment. Are you okay? Is everything okay? Just ask them. And we can it's interesting. We expect officers and law enforcement to de-escalate situations, but it starts with each of us. It starts in our homes, in our communities, in our professions. See people as people and stop and take a moment to say, are you okay? I doubt you can tell I'm sitting here in a wheelchair. I've had a very, very, very hard month. And it's, I'm sure I have not acted the way I normally do, but we take a moment and check in with each other. I don't think there's any one right way to be a defense attorney or to be a prosecutor. I do think there are a lot of ways you can screw up. And if you just follow that moral compass that led you to the law, that led you to fighting for justice and believing in the justice system, we can be the best versions of ourselves every day that we can be, and we'll be okay.
Amen. Let's see if we got any questions.
Okay. I don't see any.
I do not see any questions having come in through the chat, but again, to everyone, you're welcome to unmute yourselves now if you have any questions. Or if you think of any later, we can always get them to Shana and Mike after the fact.
We Yeah, Kyle, there's our contact information. If anybody wants to reach out, ask any questions, we're happy to talk to anybody about anything really involving the law. We were gonna do our little highs and lows about the law, but
Yeah, we can just as a
kind of
final
skip
wrap
that
up.
if there aren't any questions.
Basically, as we talked about how when it was on this slide, that's the only reason we're back to it. But Mike and I, what we like to do with trials at the end of trials or in the middle of trials is figure out the highs and lows of the case. And so my highs of being a criminal defense attorney is that I love the ideal of the law and I love our justice system's intentions. I love to help other people. I love to help other attorneys. I love to help people through very tough times. And I love to use the underlying principles of the law to illuminate inadequacies, errors, imperfections, biases, discrimination in the law, which dovetails with my lows. My lows are, our system isn't perfect, and those imperfections really hurt people. There are real results to imperfections. As a defense attorney, I had to give up my ability to really have a lot more control over the results. As a prosecutor, you have a lot more power to control what's going to happen. We are very good in trial. We are very good at what we do, but none of us can predict what a jury is going to do. So that was very difficult. And then I think my last low is that as enamored as I am with the criminal justice system, justice is at times fleeting and really hard to see and believe in. But the people who believe at the core for what our Constitution promises and are fighting to make it deliver on are the people we need to stay invested in this profession. We can't have cynicism run this profession.
So my three highs are, I love reading the law. I love applying the law. I love the geeky part of the law. I love the way the law changes all the time. It's constantly changing to try to meet new challenges. That's a good thing. I love interacting with people I've never met before, meeting new people all the time. I love being a professional. I love that our court system exists to protect all of us. And frankly, when it gets overly political, the court system is supposed to be the independent, objective thing that protects us. And I like that. The lows are the system is inefficient. It causes high stress to lawyers. It causes lots of burnout to lots of people, including lawyers. I'm a kind of high anxiety person anyway, and it doesn't really relieve my anxiety. And people can lose faith with the system making mistakes. Those are all lows, but they lead to highs when we work to alleviate or to remedy those lows. So thank you again, all of you, for attending the CLE, and we hope you learned something from it. If you want to reach out to us, please feel free.
Thank you.
Thank you again. And I will send out the presentation materials along with the CLE form here shortly this afternoon. And again, if anyone has any questions you want me to pass along, I'm happy to do that. But thank you, everyone. Have a great day.